first trial ended with a hung jury, the second with convictions on 3 counts of aggravated indecent assault. In the first trial, the court allowed the state to call 1 prior bad act witness, but in the second trial, the court allowed 5.
There's a disparity there in the numbers. Looking at the math, it makes sense to me that the Supreme Court wants to look at this issue.
Trial expert Barbara Ashcroft once served as a prosecutor in Montgomery County, where Cosby was tried, and now serves as Attorney Advisor General to the U.S. Marine Corps.
When you have 5 witnesses saying that, they were drugged in some way, they were incapacitated, they were sexually assaulted, versus 1, right? The numbers themselves speak volumes about what the members are going to be thinking, what the jury is going to be talking about behind closed doors.
Such witnesses were in addition to victim Andrea Constant, who was the named victim for the crimes charged. The defense argues the trial court erred in allowing other accusers to tell their stories for crimes never charged, specifically arguing it's prohibited propensity evidence. The trial court ruled the jury could hear the other women's stories because 1, they could be considered part of Cosby's common plan, and 2, because they show an absence of mistake.
Big picture here, I think this is going to be monumental decision, and it's going to affect the prior bad acts admissibility with many, many cases to come.
The second issue being raised is with an alleged promise not to prosecute made by former Montgomery County DA Bruce Castor. It was never a formal immunity agreement approved by a court, and it was never put in writing. Castor announced the decision by press release in 2005. Subsequently, Cosby admitted during a deposition for Andrea Constant's civil lawsuit that he would give women quaaludes before having sex with them.
But we all need to remember at this deposition, when he made admissions about quaaludes and having sex with women after giving them quaaludes, he had his team of attorneys at that deposition table. And so if he wasn't, of the mind to say, hey, listen, I'm not going to incriminate myself, he had a team of attorneys there.
The case was settled for close to $3.4 million in 2006. Fast forward to 2015, new DA Kevin Steele is elected and files charges against Cosby just before the statute of limitations is set to expire.
I work with both Bruce Castor and Kevin Steele, and I have a lot of respect for both of them. Kevin Steele was of the mind that Bill Cosby, the evidence was there, that members of the society should hear it, and they should make the decision whether or not he's guilty or not.
The defense argues DA Castor's intent was to remove the threat of prosecution, so Cosby would not assert his Fifth Amendment privilege in any civil proceedings.
I think that Bruce Castor kind of playing king of the castle, that he could give Bill Cosby total immunity. And by the way, secret immunity is a little silly. We don't have that kind of power. I don't think he had that kind of power.
The damaging admissions Cosby made in the civil deposition were introduced as evidence in his criminal case. Cosby's defense argues on appeal those statements should not have been allowed in.
So these team of attorneys also accepted the fact that there was no written documentation about this secret, endless immunity that Bill Cosby was supposed to get against criminal liability. So I think that's always an important issue for the general public to understand. He has a team of lawyers that are there to protect him.
Now, another team of lawyers is going before the highest court in Pennsylvania to protect his interests on appeal, asking the court for a new trial.
All right, let's bring in Court TV anchor Julie Grant, who has covered this story from the beginning. From the beginning. Is there any real merit to this? Any real chance of this conviction being overturned?
Vinny, that is the million-dollar question with these two issues, and I've thought a lot about it. This is going to be a tough one, in my opinion. I think this is going to be really, really tough for the Supreme Court to decide to vacate these convictions. But his team of lawyers, they are certainly trying and putting up quite a fight. Their brief was so detailed and so well done. They're going to put everything they can into this. And the standard of review here is what's really key. We're talking about abuse of discretion here is the standard. So this is pretty high in terms of that evidence when we're talking about those prior bad act witnesses. And I want us to take a listen now to more of what attorney Barbara Ashcroft said about that. Let's listen.
The standard of review here is abuse of discretion by Judge O'Neill. That is a very high standard of proof. So defense in this case, they're going to do a lot of spinning. Certainly they've got some ground to cover, and they have to do their job and advocate for Mr. Cosby. But at the end of the day, Bill Cosby's not getting out of jail. And I don't see this conviction being overturned. Now, that is a prosecutor talking, but that's what I see.
And Vinnie, Barbara Ashcroft was at one time a prosecutor who practiced before Judge Stephen O'Neill, who was the trial judge in the Cosby case. And she recalls him being very fair, very thoughtful, very intelligent judge. And one thing I found really interesting was that she can recall a child sex abuse case that she tried before him. And he limited her so much so with prior bad act testimony that he didn't allow any in during the guilt phase of the trial. She was confined to only introducing those witnesses in the penalty phase. So again, this is going to be a big decision. Lots of eyes on this one, Vinny.
So we're here in the midst of the Me Too era, and we're watching a lot of these cases like Harvey Weinstein, where you have these prior bad act witnesses. Has the Pennsylvania Supreme Court ever dealt with this issue before?
Oh, that's another good one. Yes, they have. And this was something I talked to attorney Barbara Ashcroft about, how they seem to have kind of struggled with it, Vinny. There was a big case. The case is the Hicks case, decided in 2014, and it dealt with exactly that. And the issue was really whether or not the presentation of these various stories would be cumulative, meaning the jury's already heard it, and they've already heard it, and they're hearing more of it. And so what the court essentially said was the balancing test to whether or not the next witness should come in should be done at the point of trial, not necessarily prior to trial with a motion in limine. So that's really interesting that they've kind of struggled with this. And there's nothing preventing either side from filing a motion in limine, and certainly the Commonwealth from saying, hey, look, this is who we want to introduce. Here's our offer of proof. This is what these women are going to testify to, and we want you to make a decision. So this is going to be very, very big. And I think lots of states are going to be looking at Pennsylvania, Vinny. The Commonwealth's brief is due on September 14th, so we'll see the state's response then.
All right. Julie Grant, thanks so much.
Thank you, Vinny.